Hi, everyone. We're just going to give folks a few more minutes to join, and we'll get started in just a moment. All right, we're going to go ahead and get started. Good afternoon or morning, I suppose, depending on where in the country you're joining us from. And thank you for joining us for today's webinar, a 2015 year in review of case law updates in the environment. My name is Lexi Albee, and I am program coordinator for environment here at AASHTO. I'm joined today by Bill Malley, managing partner of Perkins Coie's Washington, D.C. office and author of our CLUE case law summary. Now, before we get into the meat of today's agenda, I'd like to go over a few housekeeping items. Today's webinar is being recorded and will be posted on the Center's website, along with a copy of the slide deck and the full year in review report. All participants are in listen-only mode, but we encourage you to submit questions throughout today's presentation using the panel on the right side of your screen. These questions will be held until after Bill concludes his presentation, but again, we encourage you to submit those questions at any time throughout the presentation. Today's webinar is presented by the Center for Environmental Excellence by AASHTO. The Center for Environmental Excellence has been developed in cooperation with the Federal Highway Administration to promote environmental stewardship and to encourage innovative ways to streamline the transportation delivery process. For those of you that are not familiar with the Center for Environmental Excellence programs and services, I encourage you to visit our website at environment.transportation.org. The Center website serves as a one-stop source of environmental information for transportation professionals with case studies, past webinars, practitioner handbooks, news and recent developments, and dozens of other products and resources for the modern transportation practitioner. One of those, which will be the focus of today's webinar, is the CLUE database. So I'll go ahead and turn things over to Bill to give us a little bit more information on CLUE and take us into today's presentation.
Great, thank you, Lexi. My name again is Bill Malley, and I'd like to begin with just an overview of what the CLUE database is, and then we'll turn to the case law highlights from the 2015 court decision. So starting first with CLUE. CLUE is a database hosted on the Center's website that contains case law summaries. And these summaries reflect essentially the body of case law involving NEPA and related laws for cases involving federal highway, FTA, or FRA projects. Most of the cases that are in the database do involve federal highway, but we have attempted to include FTA and FRA cases as well when those types of projects are challenged. The time period covered essentially is from about 2007, 2008 up through the present, and it's pretty comprehensive throughout that period of time. For each case, what we have on the website is a one-page summary, approximately one-page summary, mostly bullet point, just covering the highlights of that case, together with a copy of the court decision itself. If you go on the website, what you'll find there is that there is a set of filters that you can use to select cases on a given topic or from a certain type of project, for example, a transit project or a highway project. You can filter not only by environmental topics such as air quality or cultural resources, but also by particular legal issue. And those legal issues are organized by NEPA, Endangered Species Act, Section 4F, and so forth. And then there are subcategories under each of those, for example, purpose and need. And we've included there at the bottom the link to the CLUE website. As you'll see there on the screen on the right-hand side, there are approximately 190 case law summaries that are in the database currently. So before we begin with the case law highlights, I'd like to just note a few things about NEPA case law and what kind of lessons we can take away when we look at a particular court decision. And I'm sure these points will be familiar to many of you, but I think it's just worth reiterating them before we jump in. I think first, NEPA court cases involve the application of very general legal standards like consider all reasonable alternatives. Courts have to apply those to a specific set of facts. So the result of that is twofold. One, these cases are very fact-dependent. A slight difference in facts can lead to a completely opposite outcome. But also, the judges themselves, because they're applying some very subjective standards that require interpretation, there are very few bright lines. So two different people looking at the same exact set of facts could reach different decisions. And so there's a little bit of idiosyncrasy in the cases, and sometimes a case is simply an outlier and is not one that necessarily can be reconciled with a different case. It's also important to understand and think about the distinction between a court decision that's from a district court, which is essentially a trial court, versus a court of appeals. District court decisions don't have the precedential effect that a court of appeals decision would have. In other words, the court of appeals decision is binding precedent for all district courts within the area covered by that court of appeals. So those decisions are just naturally a bigger deal. The body of law, case law that we have this year involves district court decisions. It just happens to be those were the decisions that came out this year. So they're, in a sense, on a lower tier of importance in terms of their implications, but nonetheless, I think are important because they are cited and are sometimes relied upon, at least as what's called persuasive authority by other courts. The last thing to note is that a number of these cases, and I'll note them, are still in progress. So, for example, appeals have been filed, or the cases are still underway in the district courts. And so it's possible that subsequent proceedings will result in some change in what has been decided up until this point in the case, potentially, including the Court of Appeals completely reversing a decision made by a district court. So that's an important thing to keep in mind as well. So with those out of the way, I'll turn to first an overview of the cases that have been decided this year, and then we'll turn to the individual decisions. In terms of overview, just to provide a snapshot, what I've started with is a list first of the highway projects, and then I'll list the public transportation and rail projects that were the subject of court decisions this year. And you can see they involve a wide range of both project types and locations. And when you turn to the website, you'll see each of these projects described in more detail. I've also noted here a few of them that are two of them that are currently on appeal, and one where there was a Court of Appeals decision issued in the first part of this year, and that will become subject of a new summary that's posted to the website for this year. And on this slide here, you'll see the public transportation and rail projects. So they're not a majority, but there are a good number of public transportation and rail projects that are also the subject of litigation, and I'll talk about a few of these in the presentation. One thing I'll note on this slide is that one project, the Baltimore Red Line, was the subject of a district court decision where the record of decision was upheld. There was an appeal. While the appeal was pending, the state decided not to go forward with the project. And as a result of that, FTA withdrew the ROD, and the Court of Appeals then vacated the district court decision. Vacate basically just means wiping it off the books. It's still a case that I think provides some important lessons, but it doesn't have any legal effect at this point because it's been vacated. I've also got a couple slides here just summarizing the cases by the numbers. By lead agency, you can see Federal Highway is the lead agency for the vast majority of these, not surprisingly. Just as an aside on that point, Federal Highway sometimes is the lead agency for a project that's not a highway project per se. For example, one project, the All Aboard Florida project, is basically a rail project, but Federal Highway was the lead agency for that. And you'll see other examples from time to time where the mode of the project doesn't necessarily directly correspond to the mode of the agency that serves as the lead. And this slide, I'm sorry, I'm jumping around a bit. This slide gives us the outcome, and you can see that the defendant, which is to say Federal Highway, FTA, FRA, prevailed in the majority of the cases. There were 4 cases in which the plaintiff prevailed on at least some of the issues. And this is obviously a bit of an oversimplification here because often it's a bit of a mixed result where a court may rule for the plaintiff on some issues and for the defendant on many other issues. And that was the case for some decisions this year as well. So as we turn to the highlights, what I've done here is to really cover in this presentation just a subset of the issues and try to focus not so much on the ins and outs of a particular case, but rather more at a high level, what were the issues that were brought before the courts, basically what did the courts decide, and then what are the takeaways for practitioners. So I'm kind of summarizing at a high level what I think are the important takeaways from the cases rather than telling the story in depth of each particular case. Just before I jump into this, also note on the website, in addition to the case law summaries themselves, which are one for each case, we also will have very soon a year in review summary paper, which pulls it all together and essentially covers what's in today's presentation, but in more depth. And that will be posted to the CLUE website very soon. That will be covering all of the cases from 2015, and we also have one for 2014. So to begin, I'll talk first about alternatives analysis. As is almost always the case, NEPA lawsuits in 2015 involved challenges to the range of alternatives considered in NEPA documents. It's probably the bread and butter legal argument raised in almost any NEPA case. The point that I'm highlighting here is that a lot of the challenges involved what I would call kind of coming at it from an angle, not necessarily saying that there's a huge gap, but rather that there's an additional variation, a different combination of alternatives. There was a hybrid that combined pieces of 2 different alternatives that should have been studied or that should have been studied in more detail, should have been developed more fully. So you can kind of think of it, if you've mapped out the basic concepts, that these are arguments that are focusing on something that's just slightly different from the main thing that you studied. Examples include in the Baltimore Red Line, like many transit projects, the alternatives studied in detail involve light rail and bus rapid transit, LRT, BRT. Heavy rail was considered and dismissed in screening. The alternative that the plaintiff was arguing should have been considered more fully was a hybrid alternative that was heavy rail in one portion combined with BRT in another part of the corridor. In the Wisconsin case, it was improving the existing road. 3 different versions of an alternative involving adding a passing lane, essentially improve the existing without going to 4 lanes, were studied. The plaintiff identified additional variations and said essentially the version of a passing lane alternative developed was too minimalist, too weak, a more robust one should have been developed. And then for Crenshaw LAX Transit, various alternatives were considered that included tunneling, but there was no alternative that included tunneling in the specific location of concern to the plaintiffs, and they said that was a gap in alternatives analysis. I think that in all three of these cases, the court essentially upheld the adequacy of the alternatives analysis for slightly different reasons in each case. I think the important takeaway from this is that these litigation challenges often focus on just a variant of the alternatives that you were studying that may have been considered only in passing or perhaps not at all in the NEPA document, and that variant then becomes front and center in the litigation. And the question is, why do we only have 2 sentences on this, or why was that particular alternative never studied? What saved these NEPA documents, a couple different things. One is that a particular hybrid, for example, in the red line, was considered at least in responses to comments, so that they can play a key role in kind of gap filling. And then secondly, the consideration of 3 different passing lane alternatives provided a sort of protective umbrella in the sense of that was a sign of the thoroughness, and that the request to consider a 4th combination was rejected by the court, and I think one can infer the court saying, okay, you've clearly gone above and beyond. I'm going to say that's enough. I'll turn next to traffic forecasts. This is probably the largest theme in the cases this year, the issue that's probably the most significant of the issues covered in this year's court decisions. Courts came at this from a number of different directions. I think it goes without saying this has become probably the single biggest focus of legal challenges, certainly to federal highway documents, or the most frequent challenge. And it has a number of different dimensions. One has to do with how well was the methodology explained in the technical reports that accompany the NEPA document. Can the court understand, can the public understand how those forecasts were developed? Another aspect had to do with the validity of forecasts, and in particular in terms of the actual growth rates that are projected into the future. A lot of focus on recent data that calls into question those long-term projections. For example, recent trends show very flat growth. You're projecting steep growth into the future. That suggests you're overestimating growth. Perhaps the biggest issue in this set involves no build, and in some ways it may seem obvious. Well, of course your build alternative should not be in your no build. Everyone knows that. But the underlying issue here, and the issue that's a little bit more difficult conceptually and practically, is when you think about the growth forecast in terms of population and employment, which are often received from an MPO, what assumptions are embedded in those population and employment growth forecasts? Do those, in a sense, assume the implementation of all projects that are in the MPO's long-range plan? Can you, in a sense, disaggregate the component of those population employment growth forecasts that in some ways are tied to the project, if in fact that was the case? And then lastly, MPO forecast, and it relates to this no-build issue. There's a two-fold aspect to this. On one hand, is it permissible to depart from MPO's forecasts? On the other hand, are you required to use them? Which way does that go? And different cases have addressed that from different angles. I've listed 4 cases there, and you can see each one of those cases involved some combination of these issues. The Illiana case and the Garden Parkway case are both notable because those are cases in which the court ruled, and actually Highway 23 also, in which the court ruled against the agency on some aspect of this. On Highway 23, more explanation needed on the methodology. On Illiana, the court said that the build alternative may be or was included in the no build. And then for Garden Parkway, the court also said essentially the no build forecast assumed the project. And I'm oversimplifying, but that's the gist of it. So I've got a couple slides here on these issues because of their importance. First, in terms of takeaways, I think first on methodology, what's notable to me anyway is and Highway 23 kind of highlighted this, the importance of having both a plain English explanation and a high level of detail, which may sound contradictory, but on one hand, the plain English explanation is needed so the court can actually understand this highly technical field. And then on the other hand, you also need a fairly detailed technical report because the court is saying, I need to understand how these numbers were developed. The public needs to be able to not just see the number, but get behind the number. And so that creates some challenges for practitioners. Closely related to that is these technical reports, they can be an asset, but they can also be a detriment. So the Ileana ruling, where the court said the no build was assumed or may have assumed the build alternative, was really based on not the EIS, but on a technical report. And a single bullet in one technical report was interpreted by the court to mean that the build alternative was assumed in development of the population employment growth forecast. Highlight, I think, the need to really not only have very thorough, but also very precisely worded technical reports on these issues. On growth trends, it is a given that if your recent growth trends have flattened out, that those will be used to call into question longer-term forecasts that show higher rates of growth. The underlying issue being, are you being too rosy in your predictions? It doesn't mean that you can't have long-term forecasts that are more favorable, more at a higher rate of growth than recent trends would indicate, but you've got to explain that. One thing to note here is courts do get it. They get that recent trends could be fluctuations, that they're not necessarily indicative of long-term growth, but they need to see it explained. On the no-build front, this one's probably the one I would sort of circle and put an asterisk next to more than any other issue. It's not about the obvious point that your no-build and build forecast needs to be different. It's about digging below the surface of your no-build forecast and saying, where do those population employment growth forecasts come from, and what was assumed in development of those population employment growth forecasts? And do those, in some sense, embed within them an assumption that the project will be built? Has anyone ever disaggregated that? I'm only scratching the surface there of this issue, but that really is a big deal. And while legally the burden of proof is not on the defendant, it's on the plaintiff, as a practical matter, I think it's worth thinking about this as if the burden of proof is on the agency to show that the build alternative was not in any way, shape, or form a part of any aspect of the no-build forecasts. And then lastly, on MPO forecasts, there are two different aspects, as I mentioned before. On one hand, I would say they're not necessarily a safe harbor. I mean, if those forecasts in some sense embed within them some aspect of the build alternative, then that may not be a safe harbor. It may be that you need to take those forecasts and rework them, back out anything aspect of those forecasts that reflect an assumption that your project will be there to have a truly pure no-build. Lots of questions come out of even attempting to do that and at what scale and so forth. And the court in Ileana did say it's okay to have different forecasts than the MPO's forecasts. You don't have to use theirs. And it may be that using different forecasts is preferable in some cases. But the flip side of that is that if you have a significant disagreement with the MPO, that is not a positive thing in the eyes of a court. And I think that also is reflected in that Ileana case. Keep in mind, too, that just in general, the courts are bringing a very skeptical eye to forecasts. They are rigorous in reviewing them. They don't take numbers at face value. So this is an area that really does, I think, require very, very close attention by practitioners. I'm referring here to traffic forecasts. The same would be true if you are working on an FTA project or an FRA project and you're doing ridership forecasts, the same set of issues. I've got a couple, and I won't go in detail, but a couple blurbs from these cases just to give you a flavor for it. Highway 23, methodology, court saying there's no comprehensive explanation of how the models were used to arrive at the traffic projections. We don't have the raw data that they used that resulted in the bottom line numbers. So the court's like, I'm not just taking their numbers at face value. In the Garden Parkway case, the court, came down with a pretty heavy hammer, so to speak, saying your assumption that the Garden Parkway would have no effect on overall growth in the region was not supported. So there, it appears from this statement that they're saying you almost have to have a different no-build forecast at the regional level, where, in general, the practice has been you've got the same control totals used at the regional level for both build and no-build. I'll note, as you may have seen on the screen earlier, this case is being appealed. So it may be that we don't know what the ultimate outcome will be. All right. Next set of issues involve predetermined and bias. And here the issue, it takes a different form in different cases. But the upshot is that many cases plaintiffs will say, okay, there was some predetermination of the outcome, or their actions the agency took that showed it was sort of systematically biased in favor of a particular alternative. A couple of interesting examples of this. One, Virginia Avenue Tunnel, this is a rail tunnel. It was for a CSX freight rail line, essentially. It was in the District of Columbia. The District Department of Transportation was essentially the state DOT. And the argument was, well, the district entered into various agreements with CSX that, if this project goes forward, we will do such and such to facilitate its implementation. And the plaintiff said, well, all of those agreements or other arrangements were a sign of bias. And the court essentially said that the district can have, in a sense, a preference for an outcome without being biased. And in any event, the real issue was federal highway biased. And there was no attribution. The court said there's no indication that any bias that the district may have had could be attributed to the federal lead agency. The Southwest Light Rail project involved a pretty unusual fact pattern. I'm not sure this will crop up very often, but it was an interesting case where essentially in a midpoint of NEPA, after the draft EIS, but before the final, the local government was required under a state law to go through, or the local project sponsor, to get municipal consent, meaning the local governments along the new light rail line needed to sign off on it. And the plaintiff said, well, that's going to bias the outcome of NEPA by locking in that alternative. And they filed the lawsuit while NEPA was still underway, raising that claim. Long story short, the court ultimately held that that did not bias the outcome of the NEPA process. That's a little bit one-off, but I think it shows the different ways that these allegations can come up. And then lastly, in the Crenshaw case, there was an additional alternative analysis that was done to respond to a comment on the EIS, but it was done after the locally preferred alternative had been announced. And they said, well, it's sort of a fait accompli at this point because you've already decided what you're going to do. And there the court said, no, it's part of your job is responding to comments, and you've done an objective analysis. The fact that it happened after locally preferred alternative was announced doesn't mean that it wasn't an objective analysis. Lexi, I'm trying to turn to the next page, but the slide isn't turning, so you might be able to, I don't know if you can do that.
Yeah, I think I just advanced you there.
Hold on, I'm not seeing it on my screen.
It should be advanced to the applicability of CEs. Are you not seeing that?
I am not seeing that.
Right. Well, with us here. do you have, I mean, it's showing the applicability of CEs if you have it in front of you. It says
I will, okay. I'll go for my hard copy. Okay. So I'll turn next to applicability of CEs. There are a couple cases that reached contradictory results with regard to the use of a D-list CE. As I think is familiar to most folks, the Federal Highway and FTA regs have two separate lists of CEs, C and D list, and the D list are for the projects that are typically involve some degree of documentation needed to establish the CE applies. The real issue in both cases was you have a project that didn't fit squarely within any of the project types listed. And the question was, can the agency rely upon those CEs by analogy? And in one case involving Route 29 in Virginia, the court said it was appropriate for a highway interchange to be covered under a CE for essentially railroad grade crossing projects by analogy. In the other case, which was in Florida, the court rejected that approach. And that case came at a later time, and the court essentially said, no, we're not going to follow the reasoning from the Route 29 case because essentially the court said the project you have just doesn't resemble the type of project that is in the CE. So I think certainly we don't want to read too much into an individual district court case, but I think it does suggest the need for some caution in using D-list CEs for projects that don't fit neatly within a specific D-list category. So, Lexi, if you can turn to the environmental justice slide.
Yep, it's up.
Okay. All right. On environmental justice, there was just one court decision that addressed this, but I thought it was noteworthy because it involves some issues that do come up from time to time. The issue was, there are two issues. One is, can you challenge an EJ analysis at all? And then secondly, how do you determine what's a disproportionate impact? This case involved a transit line, part of the subway system, and that transit line was located in a predominantly minority and low-income area, pretty much from end to end. The requirement for environmental justice analysis grows out of an executive order, and that executive order says essentially this order creates no rights, no legal rights, no cause of action. So courts have held that you can't sue a federal agency or an applicant for violating the executive order. But courts have also held, and this court held, that you can bring a lawsuit under NEPA challenging the EJ analysis in the NEPA document. And I'll note there are other court decisions that have reached a different result and said, no, you can't bring it as a NEPA lawsuit if you can't bring it under the EJ executive order. But in any event, this particular court did allow it to be brought. And I think that's certainly an indication that, at least in some cases, courts will allow that analysis to be challenged as part of a NEPA claim. Related question was, okay, what is disproportion? How do you determine disproportionality? And, again, this goes back to the executive order, which requires federal agencies to assess whether their actions will have disproportionately high and adverse effects on minority and low-income communities. The aspect of that that's always challenging is how do you determine what is disproportionate? And what the court was concerned with here was aspects of the EIS that seemed to look at proportionality solely within the project area and essentially said, well, the entire area is minority and low income, so it's not just proportionate. And the court said, no, your analysis needs to be kind of comparing the project area to areas, some larger area, whether that's the state or the region or the county. And ultimately, the court found some statements in the NEPA document, including responses to comments that indicated that broader lens was used. So one, I think, takeaway from this is to think about proportionality not as just being something that's one part of the project area to another, but comparing with a project area to some larger area. With a judgment call needed to be made about what that larger area is. The court also noted, in a favorable sense, that this analysis took into account the benefits as well as the impacts on that community. And this is almost a classic example of a project that, in order to serve a minority and low-income area, it's also having impacts within that area, and that the court recognized you need to look at kind of the net effect and the fact, yes, the impacts are there, but also the benefits that's necessary in order to provide those benefits. We'll turn next to the combined final EIS and ROD.
You're up.
Okay. And on this issue, the legal backdrop is that in MAP 21, Congress passed a law, what's called Section 1319 of MAP 21, that in fact required that the final EIS and ROD be included or issued as a single document in some cases, with some exceptions. And the question is, okay, in a given situation, when that document is issued, together, the final and the ROD together, was that permissible? And so the plaintiffs in this case argued that, in fact, there were significant new circumstances or information that required Federal Highway to issue the ROD separately, essentially precluded the final and the ROD from being issued together. And the court looked at that language and said essentially, okay, that's the same standard that's for preparing a supplemental EIS, same exact language. So we're going to interpret it to mean the same thing. And therefore, if a supplemental EIS was not required, then there was also nothing precluding Federal Highway from issuing the final EIS and the ROD together. I think that's an interesting point, because what it would suggest is that if you're precluded from issuing the final and the ROD together, not only is that the case, but you also need to issue a supplemental EIS. And this particular court decision doesn't really explore the implications of that. But essentially the court is saying these two standards are kind of the same standard. And so I think the implication is that if you have significant new circumstance or information, you can't combine your final and ROD, and you need to issue a supplemental EIS. Just as an aside on this point, in the FAST Act passed recently, this language that was formerly in 1319 of MAP 21, not really codified in Title 23, is now codified and is in Title 23, but it's the same language that was there before.
And we're on litigation issues.
All right, great. On this last slide, or last slide before we turn to the Q&A portion, I cover a handful of litigation issues that don't involve actual compliance with environmental laws, and there are more of these that are covered in the year in review summary paper and that are on the website. But just briefly, a couple things I thought were of note that are of general interest, not just to lawyers. The first has to do with attorney's fees. There's a law called the Equal Access to Justice Act, which essentially allows a prevailing plaintiff in a lawsuit against a federal agency to obtain attorney's fees in some cases. And it's still a judgment call a court needs to make, but the concept is that at least in some cases, the prevailing plaintiff can obtain attorney's fees. And the question is, well, okay, if you're a state DOT and you've received NEPA assignment from Federal Highway, let's say, you are now a federal agency for purposes of NEPA. So can attorney's fees be awarded against that state DOT, just as they would be against Federal Highway? At least in this one case, the court said no. The court took a very literal reading of the Equal Access to Justice Act and said, I've looked at 600 cases. There's never been one that awarded attorney's fees against anything other than a federal agency. So no attorney's fees. And so that's where at least that court came down. On statute of limitations, this is essentially the deadline for filing a lawsuit after a decision has been made. Federal highway projects, FTA projects also are subject to a 150-day statute of limitations if a Federal Register notice is issued for that federal decision. If it's not, there's a 6-year statute of limitations, which is kind of the default that's there in the background. One of the questions that often comes up is, well, if you have a record of decision or other, NEPA decision document, that's one deadline. Everyone gets that. But what about those reevaluations that are done afterward? Does each one of those trigger a new statute of limitations deadline? And generally speaking, the answer to that is yes, and this court recognized that and said, look, we're going to do our analysis for each one of those reevaluations separately, and the most recent reevaluation is itself within the statute of limitations period, so that can be challenged, whereas earlier reevaluations are outside that period and cannot be challenged. So this is something to think about just in terms of agencies that perhaps have some discretion in terms of when those reevaluations are done and what they include and so forth, and just thinking about those as each challengeable actions, at least in many cases. Lastly, on the administrative record, in these kinds of cases, courts are required to base their review on the administrative record compiled by the agency. There's often litigation over, is that record complete? And there's lots of case law on that point. The issue in this particular case, this is Virginia Avenue Tunnel, so recall that that was the case where the plaintiffs were alleging bias. And they said there's all these arrangements that have been made with the private developer of this project, and those collectively reflect some form of bias. They're trying to prove that. So they essentially said, we want to add in certain, all communications between these parties with regard to these issues. And the court essentially said, no, we're not going to do that. To supplement the record with additional documents, you need to really identify specific known additional documents. It can't just be a general, statement if I want everything on X. The court also rejected the plaintiff's request for discovery, and discovery essentially is a legal proceeding where you can obtain documents and sworn testimony from other parties to a lawsuit. And typically, discovery is not allowed in a NEPA case, but it is allowed or can be allowed by order of the court if the court finds that there's evidence of bad faith on the part of the defendants. And if you can imagine a hypothetical example where there was an indication the agency was hiding documents or destroying documents, the court would allow discovery to say, okay, well, I can't trust this agency anymore, so I'm going to give you the ability to go take sworn testimony and find out what the truth is. That's a very, very rare thing. And in this case, the court said, I'm going to deny your request for discovery because you just haven't shown that there was bad faith present. So that's the last topic that I have on the slide here. There are a number of other litigation issues that we cover in the case law summaries, and they involve issues such as who can sue and when can a lawsuit be brought, when is a lawsuit moot, and so forth. And if you read the cases, you realize a lot of what courts have decided involve those issues, which are not environmental law issues, but they do affect the ability of a plaintiff to bring a case and the timing of it, and those issues can be important in a practical sense for practitioners. I'll mention just two things that are not on the slide that relate to those other cases. One involves who can sue, and the other is when you can sue. On the who can sue issue, there's a whole body of case law that says that in order to bring a NEPA lawsuit, you need to have an environmental interest that's sort of within what the courts call the zone of interest protected by NEPA. And so courts have said if you're just a property owner or a business and your only interest is an economic or what they call commercial interest, you're not a proper plaintiff for NEPA. So lots of cases have bounced lawsuits from local businesses that are affected. But there are also cases that say, well, a business in some sense can have an environmental interest because, say, its employees are affected by the emissions or the aesthetics or what have you. So it's an area where courts really diverge, and this was another example this year. There are some cases saying it's a local business owner and they can sue, and then another case that said they're a business owner, they can't sue. And I'm not sure the courts will ever really come down on one side or another of that fence. I think takeaway would be you just assume that there's at least a possibility that almost any stakeholder that's affected could be a plaintiff. There are just some additional question marks if it's more of an economic interest. And then, so that's on the who can sue. In terms of when, mootness is an issue that often comes up where people say, well, we're already under construction. Our project's almost built. Is it really possible for somebody to still file a lawsuit? And there have been cases over the years, and there's another case this year where, and even though the project was very far advanced in construction, the court declined to throw the case out as moot and said, well, there's still some relief we could provide if the plaintiff were to prevail. For example, additional mitigation. And so I think it underscores that while mootness, every case becomes moot at some point, courts in NEPA cases are reluctant oftentimes to throw cases out as moot, even when construction is well underway. And that was the case, again, in this one lawsuit. So I think we've got about 15 minutes remaining here. Lexi, I'll hand it back to you, and we can turn to the Q&A.
Do I have you, Bill?
Yeah, I'm here. You were silent, so I didn't hear you.
Sorry.
I can hear you now.
I have one point of clarification, I think, on the statute of limitations from the previous slide. Does that mean that the final record of notice should be issued for each reevaluation?
Good question. It can be. That's really the answer. And it's a strategic question as to whether it should be. But each decision can't, Federal Highway or FTA has the ability to issue statute of limitations notice for each separate decision. They typically don't, but they have the ability to do so, and so that's a strategy call.
Okay. And what indications have case law provided for legal sufficiency in the context of environmental document quality?
A couple things I would note.